Chair, I would just ask that you go over the rules for appeal another time.
Absolutely. Yeah. The rules for appeal basically, Eric, I believe you're familiar with that, keep it 15 minutes for the appellant, 5 minutes for the police officer present, 10 minutes for ABQ, 10 minutes for the IRO, and 5 minutes for your rebuttal. Is that understood?
Yep, okay. I have some handouts for the IRO and for the commissioners.
Good, sir. Wait. I guess we had reached out to you earlier this week to see if there was anything else you wanted to introduce, and I was under the impression that there was not.
Chair, Mr. Aronson has handed me a stack of documents. Mr. Aronson has handed both myself and the two commissioners present one original document and then pages from the appeal record which the commission had received.
Okay.
And the original document
No, I am reading it.
looks like written of his statement, is that correct?
Yes. Yeah, so it's just basically what I don't know if I'm gonna, it's basically what I planned on saying here today, and some pages from the IRO's investigative file, which I wasn't sure you all had or not. So that's all this is. There's nothing new here. So, is that all right?
Okay. Very good. Go ahead, proceed, please.
Okay. Being that I filed my original complaint in this case on October 2nd, 2012, and I now stand here nearly 2 years later, and due to what I can only call foot dragging by the IRO and to some extent the POC itself, I realize that no discipline will be handed out by the chief even if I were to win this appeal. I had planned to aggressively defend my allegations, but after realizing that nothing will be done, and after rereading the DOJ's findings concerning the current IRO and the weak police oversight structure of this commission, I see that it would be an exercise in futility. So what I have done is I have given you gentlemen and the IRO copies of my appeal statement and copies of the pertinent pages from her investigative file, and I simply ask for you to come to your own conclusions. However, I do think it's important that the people know that the IRO knew early on in her investigation that I did have a valid complaint. And by this, I refer you to page 30 of the investigative file, where on November 1st of 2012, which was roughly a month after I filed this complaint, someone inside APD knew that this was a repeated problem and was asking for suggestions that anyone might have to rectify the situation. Also on pages 25 and 28, dated December 28, 2012, where the IRO's investigator found that the officer in question violated New Mexico Criminal State Statute 66318, which is reinforced by Statute 66615, and that this information is completely missing from the IRO's findings letters to me dated December 13th, 2013, nearly a year later, that you will find on pages marked 49, 50, 51, where she exonerated Officer S of any wrongdoing. There is no doubt in my mind that if the IRO and APDIA had dinged Officer S on these criminal law violations, it would have had a cascading effect, and that all of my allegations of APD practices and policy violations would have been validated, which would have caused disciplinary actions for not only Officer S, but for her chain of command leading all the way up the ladder to the chief himself. Saying all of this, I plan to move forward, and if nothing else, I would like to know if this situation has been rectified and if it is now being properly managed and monitored by an assigned city employee. If it has, then this complaint was, at the least, effective. If it has not, has this been done, Ms. Hammer? And if it has, I ask that I be provided the information. That's all I have to say.
Okay, so that's that concludes your portion of it, and, not that there's any. Yeah, okay. Next speaker then?
Acting Lieutenant Madrano will present the presentation from ABQ.
Okay.
Commissioner Peterson, Commissioner Barker, Commissioner Foster. I'm Acting Lieutenant Madrano for the ABQ Department's Internal Affairs Unit. I was not provided the paperwork by Mr. Harrison with regards to his appeal reference this particular investigation, but I can comment on with regards to whether or not this was rectified and what procedures have been placed with regards to this particular situation involving temp tags. On October 11th, 2013, one of our deputy chiefs sent a memorandum to our chief of police at the time with particular concerns on the temp tags and the independent review officer's concerns about it. The deputy chief agreed that the department should do a better job of ensuring that our vehicles are driven with a valid temp tag or license plate. The deputy chief spoke with the fleet manager for our department. He was then informed that there was an issue with issuing license plates on the MVD side. The deputy chief then spoke with a representative from the MVD. It was decided at this time that if there is a delay in receiving a license plate from MVD, then the fleet manager will have the authority to go into a system with the approval of MVD to issue 2 additional temp tags totaling 90 days with regards to having a valid temp tag and driving. But it is their hope from the MVD that it would be streamlined faster. That way the additional temp tags do not have to be issued. The actual representative from MVD advised that they were looking to streamline it to make it quicker and within a week issuing a license plate for the department. The deputy chief then had the sergeant from Ops Review to prepare what was the information given to him to be placed into the SOP as a revision. Now, those SOP revisions state when issued a new vehicle, personnel responsible for ensuring that a temporary tag is valid and will notify operations review for issuance of a new temporary tag or license plate prior to the expiration date. Operations review will ensure personnel receive their new license plate or replacement temporary tag in a timely manner. When personnel are notified to pick up a license plate, it is the responsibility of the personnel assigned to the vehicle to ensure they retrieve and sign for the license plate prior to the vehicle's temporary tag expiring. So the deputy chief was able to come up with a solution with the fleet manager and MVD personnel to ensure that our vehicles are registered and are able to be driven on the road. It's also ensured that within the SOP that it is the responsibility of the officer who has a vehicle that is waiting a license plate or does have a temp tag, that they continue to advise operations review with regards to whether it's going to expire or when they're going to receive their license plate. So for Mr. Arison, this is an SOP revision, so our SOP is online, so he'd be able to able to retrieve that from the internet. And I can stand for any questions from the commissioners.
Lieutenant, and Mr. Aronson, I'm under the impression that your appeal is in relation to the officer, as to whether the officer was in fact operating in accordance with the SOP. Is that correct? So I guess I'm missing it. Why are we discussing issues outside of the fact that the officer either violated the SOP or did not violate the SOP? If that is the problem, and this officer was in violation of state law, my question is why didn't somebody call the Bernalillo County Sheriff's Department to come down and issue a citation to that officer for that information? But the issue that we have is that, as I understand it, is in relation to this officer, whether this officer did or did not act in accordance with the SOP. Is that correct, is my understanding? Or am I?
The original complaint by Mr. Aronson filed a complaint against the individual officer and Chief Ray Schultz, who is no longer an employee of the Albuquerque Police Department. So we have no jurisdiction over Chief Schultz.
I'm sorry, IRI, I'm not hearing you in relation to that. Old age is tough these days.
Mr. Aronson's complaint was about the individual officer, Officer S, and Chief Ray Schultz, who is no longer an employee of the Albuquerque Police Department.
Thank you.
Okay, two things. Commissioner Foster, just asked again, speaking to the microphone, that would help me. And then I guess the second thing is, from Mr. Aronson's, what he had to say up front, there, it sounded to me as though he's no longer appealing it, and so the futile, according to him. So if we're not actually appealing it, I guess we're more or less just discussing it. So the procedure just says, since the ABQ spoke, Ms. Hammer, the IRO has 10 minutes to speak if you wish to.
Chair, I would just ask that it be clarified that in fact Mr. Aronson is withdrawing his appeal from Mr. Aronson.
Mr. Aronson, did I misunderstand that? I mean, this is an act of futility. Are you not appealing it? Are we just kind of discussing it?
Yes, that's true, and yes, and I would like to see this discussed, and I'm glad to hear from APDIA that something has been taken care of here. I'm a little surprised by all of this information, because back in April, mid-April this year, I filed an IPA request for this type of information, and I was told that there was nothing. There was no documentation, no interoffice memorandums, no emails, no discussions with the motor vehicle department, nothing, absolutely nothing. I got 0 pieces of paper. So I'm a little surprised that I'm hearing this now. So yeah. And oh, by the way, this wasn't just against the officer and Chief Ray Schultz. This also had to do with her chain of command, which is written in the SOPs. The SOPs state that that they cannot afford a subordinate to violate any law, state law, federal law, local law, whatever. So this included her entire chain of command. I just wanted to clarify that.
Well, let me ask for clarification also, Mr. Aronson. So you're saying that you have withdrawn your appeal?
Yes, I think it's an exercise in futility at this point, because so much time has passed, which I don't understand why. When the information was readily available within 60 days, 45 days that are in the investigative file that shows I had a valid complaint. And it took a year before it was brought here, and decided that the officer was exonerated of everything. And then I was given this letter on December 13th of 2013, over a year later. And then I've been shuffled around by the IRO by not giving me the investigative file in a timely fashion, and then by this commission itself because of this thing or the other for the last, well, here we are, what is this, August? 8 months. So I think it's futile. It's futile. Nothing. I can't see you guys bringing it. I won another appeal at one time, and it too was drug out to some extent, and there was no discipline done to any of those officers. So I don't expect there to be any discipline done here. It's futile.
Mr. Erickson, so when did you make that decision to withdraw your appeal? Because we still have it on our agenda as an appeal.
This morning. I asked for some more clarifications from the IRO, and she promised me, this was July 15th, we had a meeting. She promised to get back to me with those clarifications by the 5th of this month. I got clarifications 2 days ago.
So this is in fact a exercise in public forum?
Yes.
Not an appeal?
Yes.
Okay, well, you're very obvious that I've been in receipt of your emails and discussions with the IRO. I recognize your frustration and the time it's taken to get to this point, but it sounds as though progress has been made, albeit sometime later. So,
Well, may I just say one more thing? Well, again, I did a IPRA request around the 18th of April of this year asking for any information as far as what the department went through with the motor vehicle department to get this situation rectified. I was told there was nothing, no interoffice emails, memos, changes to SOPs, absolutely nothing. And now here today, I'm hearing a different story. So I'm very disappointed on what's going on here. An IPRA request is law, and that's serious. That's serious business we're talking about here. Now, as I said, I would like to be afforded. I'm pleased to hear that this was effective and that changes have been made. But I think that I did do an IPRA request, and I have been stymied, if you can say that, for the last darn near 2 years on this thing. And I think I should be afforded the information on how all this went together, on how the SOP was changed, and how the department is now operating with the motor vehicle department. Thank you.
well,
Mr.
in
Erickson?
reference to the glass half full, I think we'll go with the fact that you're pleased to see that there have been some changes made, and not go with the fact that you're disappointed in the time it took to get here. I think now that since this is no longer an appeal and it's just a discussion, I think this will all be captured in the minutes. I think the information can be given to you after this meeting. So I'll call that a win.
All right, I call that a win-win myself. And I'm glad that the officer isn't really getting dinged for this, because it's not really her fault. You know, I mean, what choice did she have except to not drive her car for a month and walk, I guess. And then, of course, there is other information in this investigative file that there was as many as 21 cars being driven that way. So this is a serious issue at the time. And I have a feeling that's why it was drug out for so long, because it was basically a Pandora's box. So anyway, I appreciate it, and let's just call this a win-win. And I would really look forward to getting the information. The IRO has my address and phone number. Thank you very much.
Great, thanks for bringing this to our attention. IRO, you do have the opportunity to speak to this if you so wish. Other than that, we can go ahead and move on.
I just have one thing to say, is that the memo that the lieutenant, acting lieutenant Madrano read from, referring to the APD's response in resolving the issue, was provided to Mr. Aronson in his appeal packet on page 37, which was from the deputy chief to the chief of police at the time, explaining what the department has done. And acting lieutenant Madrano referred to that memo and outlined it orally today, but it's been previously supplied to Mr. Aronson, I believe in late March, if not early April of this year, on page 37 of his appeal packet.
Okay, well, although it wasn't listed as a discussion on the agenda, we'll treat it as such, and we'll conclude that discussion now and move on to the CPC.
At this time, with the exceptions of CPC 117, 14, and 20312, I would ask that the commissioner request that the CPCs, which have been provided to the commissioners and which will be fully reflected in the minutes, be approved as written on a consent agenda.
So moved.
I'll second
It's
Okay,
been
any
moved.
discussion? Okay, all in favor of the consent agenda with two exceptions, say aye.
Aye.
Aye. Okay, that's unanimous. All right, Ms. Montgomery.
With respect to CPC 203-12, I would say that this is a case in which there was a 3-car accident, and the complainant alleged that the report was improperly written and did not accurately reflect what happened. When a review of the lapel camera showed that the investigating officer, Officer H's report was
IRO. I'm sorry for interrupting you, but I thought we had another appeal on the agenda.
no more appeals and non-concurrences.
I'm sorry. Thank you.
And then there was a PSA that was present who did not record the incident in its entirety. And at the time of this incident in 2012, the SOP did not distinguish between the primary and secondary officers. At that time, all officers who were dispatched or employees, which would cover the PSA, were required to record the incident in its entirety. And so therefore, I found that that the PSA with respect to the lapel camera issue should be sustained. I ask you to adopt the letter, to approve my letter as written.
Okay. I move to approve CPC, the 203-12, is there a second?
I'll second that.
Okay. On the discussion side of this, I'm the one that has to have this withdrawn, and I guess my question, and I think you spoke to it, was that the SOP at the time made no exceptions for PSAs. My question was, I'm curious why the primary officer reporting the incident wasn't sufficient. But I think you spoke to that. Does the SOP agree to say now? I mean, if the primary officer is reporting the incident, would the PSA still be required to do so?
Only if the PSA, as the secondary officer, were separated from the primary officer. One recording is required that records presumably the incident in its entirety on dispatch calls for service. And PSA were to interview people separately outside the presence of the primary officer, they would be required to record it. But there's a delineation between if the secondary officer is separated from the primary officer.
Okay, so there's no delineation between, I mean, that's the same as the SOP for a primary and secondary officer, so PSA follows the same rules.
Yes.
Okay. All right, any further discussion from the other commissioners? motion and a second. All those in favor of accepting the finding of 203-12, please say aye.
Aye.
That's unanimous.
The next one, which was requested to be off the consent agenda, is CPC 117-14. This is an inactivation case in which the person sent us an email but refused to give us their last name or to electronically or otherwise sign their complaint. It's an allegation that an officer used excessive force while arresting a DWI suspect. This case was investigated by Internal Affairs on the own motion of the department, but because this complainant did not sign their complaint either electronically or manually, we have no jurisdiction to investigate it. I ask you to adopt the letter as written.
Okay, so I move to adopt CPC 117-14. Is there a second?
Second?
Okay, did I hear one? Or no?
Yeah, second.
Okay, thank you. On the discussion, again, this is me. I guess I'm curious the fact that since it didn't meet the requirements of us having jurisdiction over it, we are not privy to the results of the investigation. Is that pretty much sum it up?
Acting Lieutenant Madrano is prepared to address what can be released at this point with respect to the Internal Affairs investigation.
Okay, thank you.
Commissioner Peterson, Commissioner Barber, Commissioner Foster, this particular CPC was in fact investigated as an internal situation, and it was fully investigated. So I would not be able to speak on that investigation due to the fact that it's an internal investigation.
Ken?
So I'm clear what you just said is it was investigated, but you're not able to speak to it. Is that right?
That is correct, sir.
Okay. Well,
And with the complainant, and I'll put this in the letter, the complainant could request through IFRA whatever public record documents there are through that Internal Affairs. If an officer were disciplined, then there are documents which under the rules of IFRA someone could get. And so we'll explain to the complainant how he could do that if he so chose to do so.
okay, well, that's the information I guess I needed. Is there being a motion and a second? All those in favor of adopting
Wait a minute.
117-14, please say aye.
Commissioner Peterson,
Commissioner Foster has some concerns.
we have some
Sorry,
additional,
Commissioner Fox, please.
we have some additional questions. So are you saying, Lieutenant, that an internal request was submitted to your agency or your department in relation to this matter, independent of this person seeking information from us?
It came to the department's attention, reference this particular incident, and the department chose to go ahead and conduct their internal investigation.
And we are unable to get involved in this at IRO because of our bureaucratic limitations, i.e. a person's full name, address, and signature, etc.
I wouldn't agree with the bureaucratic limitations characterization, but we only have jurisdiction as granted by the ordinance, and the ordinance and the police union contract requires that the signatures be, that this only investigate signed complaints, which this was not.
Thank you. Thank you, Commissioner. Commissioner Barker, do you have something? Nope.
I believe this discussion is over, Chair.
Okay. All those in favor of adopting the findings of CPC 117-14, please say aye.
Aye.
Aye. Was that unanimous, Commissioner Foster?
It is, sir.
Okay. Very good. So that concludes the CPCs.
I believe that we're ready for the non-concurrence section of the agenda. The first non-concurrence case is 112-12. And this is a case in which there is a dispute downtown, and that there were an allegation that there was a fight, and that the complainant sustained injuries. The allegation was reviewed with respect to this allegation, and I determined that the allegation to be based on false or invalid facts, and moved to, or submitted a finding as unfounded against the detective. And then this is a case which was originally investigated by an IRO investigator who left the employment of the city of Albuquerque in 2012 and was reassigned to a current investigator, Investigator Scotch-DePole. When Investigator Scotch-DePole attempted to follow up on the original investigator's questions of the detective, it was determined that the detective was on military leave and not available. The original investigator had not asked the detective about whether or not to report the incident due to his own lack of diligence in the investigation. By the time the investigator Scotch-DePole interviewed the detective, it was past the 120 days that re-interviewed him. It was past the 120 days that officers are required. The officer stated that, Detective W stated that if he had made an arrest, he would have tagged the video into evidence, but no arrest was made in this case. So therefore, no video was tagged. And so therefore, the correct finding should be not sustained, which is what the chief of police and the chain of command stated. So therefore, due to no fault of his own, but there was an independent witness to the event which substantiated what the officer said, that it was not the officers who attacked the complainant, but unknown other persons. And because they were never identified, therefore no arrest was made. And in the same way with respect to all of the other detectives, the allegation that they were the ones who inflicted force against the complainant, I found those to be unfounded because the independent witness, who had no relation to the police or to the complainant, just another patron of downtown, observed that it was unidentified suspects who fled before the police got there, who beat up the intoxicated complainant on this incident. And if, Chair, if there's still questions, then we can have Acting Lieutenant Medrano explain the department's position with respect to the law document.
Okay, so before we move into this, I'll go ahead and move to approve the finding of GPC 112-12. Is there a second?
I will second it so we can get to some discussion.
Yeah.
Okay, all right, so a motion and a second, is there any discussion?
Yes. Again, I'd like to be explained, it was sustained that the officer did not log his videotape into evidence because there was no arrest.
That he was not sustained because of that. He was required to keep it for 120 days. He would be required to log it into evidence if there were an arrest. There was no arrest, so therefore, after 120 days, the officer is permitted under the rules to destroy the tape. And this is obviously the old system. Right now, under the new cameras, they are fed into a cloud, if you will, computerized storage, so it's not up to the individual officers to download it off, like basically like an MP3 player type storage unit and put it onto a disk or onto a computer. That was the old system. The new system allows downloading directly into a storage system, which the evidence department maintains. Whether there's an arrest or not an arrest, it's just downloaded. But the old system required officers to download at the end of every shift, their recordings and keep what they downloaded for 120 days. And the officer did do that in this case, but due to the personnel inadequacies of the IRO's office, it was not collected before the 120 days were up from the previous investigator who was left the employment of the city of Albuquerque. And so when we got to him, when Investigator Scratch-Nicole asked the detective, please give us a copy, it was past the 120 days. And in addition, some of the delay was attributed to the detective who was on military leave for part of that time. So the time expired, the 120 days expired for two reasons. One, the IRO investigator, the previous one, did not ask him for it within a timely manner. And secondly, in that period of time, he was on military leave, and the 120 days lapsed while he was off from military leave, excused leave.
So we don't, as soon as we get a complaint, in this case, the complaint came in, 5 days after the event, then we don't say, okay, hold all the evidence, we just went ahead and let it go for 120 days?
The previous investigator interviewed the detective relatively short in time from when we received the complaint. The previous investigator did not ask for the tape. Through why he did not, I do not know. Inadvertent error, he made a mistake. He just didn't do it. And when I reviewed it, I asked for follow-up from Investigator Scratch-Nicole, who was still under our employment, and that's when we determined that it was destroyed before we could obtain it. But what's important here is that there was a third-party independent witness who observed the entire incident. So it's not, some cases, we don't know what happened. It's he said, she said, between the officer and the complainant. In this case, we know from an independent witness who has nothing to do with the complainant or the police, just another patron of downtown, that, and she's the 911 caller, who called the police to say that this man's being beat up, the complainant's being beat up. And we have the records to substantiate her story as well. So in this case, the lapel camera isn't as important as it is in other cases where we don't have third-party independent evidence. In this case, we do have that.
Well, we have, is it a statement written somewhere?
I believe so, yes, and she was interviewed as well by our office.
Then that should have been taped.
Our office has a recording of her interview.
So that's perfect, and this is one of those cases where had we taped it and saved the tape, it would exonerate the officer. As we found up here, we see a lot more pluses for our officers that tape things accurately and totally refuted complaints. And this would have been one of those that we.
Well, in this case, the officer was exonerated. It's unfounded, which means that we found the facts to be false through the independent third witness.
Right, but again, our commission doesn't have that evidence, and it's like you said, he said, she said, the witness said that this happened, okay, fine.
It's the person who called 911. We have a recording of what they were saying as contemporaneously as it was happening. It's a credible third-party witness that I found to be enough evidence to exonerate the officer in finding that the allegation was false based on invalid facts.
And I would think it would be of a non-concurrence that evidence should have come to this tonight. If we know that we non-concurred because of not providing that information before, then certainly it should have been included this evening.
It is included in my letter, which is until there's an appeal, the amount of evidence that the commission receives.
I would like to see the video, and I would like to have heard the 911 call. And I'd like to have seen a written statement by the witness.
Okay?
Okay, it's been moved and seconded. So, Mr. Chairman.
I have.
One more question.
Lieutenant, this is for you, sir. In relation to SOP,
I'm listening, sir. Yes, sir.
If an officer is under investigation by our organization, is the officer the only person to have the code to his lapel camera to release it?
I don't understand, sir. You mean the code? I don't understand. I mean,
Well, they're evidently, every officer, when they download their video, they have some type of number or code that is unique to themselves, and they in turn tag it in relation to certain codes in accordance with the SOP. My question is, the officer, it was said to us that the officer was on military leave, so therefore we did not, or there was no access to that evidence.
Okay.
My question to you is the officer the only one who can release that evidence?
this will be a two-part answer. First of all, with regards to CPC 112-12, based on the investigation that I've read by the IRO's office, it appears that the officer had a lapel video camera, one that you have to activate by hand in terms of hitting the button twice. Now, with those lapel video cameras, the officer will download the video recording onto their hard drive. Okay? At that point, if they need to make a copy, they will make a copy and then tag it into evidence. Now, with regards to the new TASER video cameras, those are uploaded, like the IRO said, into a cloud. There are certain officers, commanders, supervisors who do have the ability, along with the officer put it in, to view that video and to go ahead and download it and provide it. It also gives an audit trail on who's viewed that video, what actions any officer took with regards to that video. So if need be, someone could have gone into the evidence.com and request that video downloaded, or go through our evidence to have it downloaded. Now, with regards to this one, it appears that it went to his hard drive, so he would be the only one to be able to provide that video if it was asked for.
When he goes on military leave, does he keep all his departmental gear with him? Or does he turn it in until he comes back from military leave?
He can turn it in, or he can keep it secured within his residence, but with the exception of the patrol vehicle would have to be placed at one of our substations or one of our fleet maintenance so that it's secured there. But he or she can keep the department-issued equipment at home.
And that includes I call them MDTs, they're called something else.
Yes, sir.
So that includes the MDT and all of his CDs.
Correct, sir.
Thank you.
Yes, sir.
Yeah. Commissioner Musgrove, anything further from you?
Sure.
I'm finished, Commissioner.
Okay, I had one question and one statement, I guess. The question is, we're saying that the evidence was logged in, but since it was past 120 days, was deleted for the SOP. Is there a log that shows that it was there and then was deleted? I mean, is the record kept of what was there?
What the not sustained finding with respect to the recording is that we can't prove one way or the other. That's what it is. It's not sustained. It's not exonerated against the officer with respect to the lapel camera. We can't prove that he recorded it. He said he recorded it, but because of the shortcomings of the original IRO investigations and the compounded with the officer's military leave, we cannot prove it one way or the other. So it's not sustained.
Right. So that's the question, and I guess the statement part is you referred to the neutral third-party witness, and that's why the officer's exonerated and stuff. And I agree on the other SOP items that helps in clarifying he said, she said. But with regard to the lapel camera video, the third person is not even a factor. I mean,
That's correct. With respect to the lapel, the independent third party is not, did not weigh into my decision. What weighed into my decision is, can we prove that the officer didn't do it or not? No, we cannot, unfortunately, because of two things. The military leave, which the officer was approved for, and that by the time he got back from leave, it was past 120 days.
Okay. So this is a tough one for me. Obviously, the officer shouldn't be faulted for being on military leave, but at the same time, he shouldn't be exonerated because the IRO's office, the investigator at the time, didn't do his due diligence. So,
But I'm not exonerating him. I'm saying he is not sustained, which means we can't prove it for two reasons. One, the military leave, and two, the initial interview, which was done before he left on military leave, the IRO investigator at the time did not ask the question. So we have no evidence one way or the other. And he's not being exonerated, and not sustained on a personnel file is a different finding and treated differently than an exonerated.
And so IRO, with that, there is no conflict between the chiefs, the APD, and us, is that correct?
But between the chief and myself, yes.
So when we are going to take a vote, we are taking a vote to accept your amended documents along with the explanation when it goes back to the chief.
It would just go back to the office. Well, the letter would be sent out to the citizen, and the file would remain in internal affairs for the officers, the subject officers' internal personnel files.
Ms. Hammer, can you repeat Commissioner Foster's question for me? I can't hear what he's saying.
He asked what happens now and what are we voting on. Is the vote the chief of police agrees that it should be not sustained. And so the chief and I are in agreement with my amended letter. And that was his question.
Okay. So is there any further discussion? Okay. So, again, I'd ask the commission, speaking to the microphones on this one, but all those in favor of approving TPC 112-12, please say aye.
Aye.
Opposed would be me. So that was 2 for and 1 against. Does that sound right?
Well, is this letter going to be amended?
Yes.
And Commissioners, I would like to see the amended letter come in front of us before we vote, but we've already started that process. So it is. So my vote is a no.
Commissioner Barker was for, Commissioner Peterson and Foster against.
So what I would suggest, under our rules, the POC must approve the letter before going to being sent. And so the letter could be amended to reflect that the POC disagreed with the findings of the chief and the IRO, but approves the letter as the form. You have to approve the letter in some form before it can be sent. Otherwise, this person will never hear what happened.
I believe we have the option of sending it to the mayor's office.
No. It has to be sent to the citizen. If the citizen appeals, then you can hear the appeal. And if the citizen doesn't appeal, then you can send it to the mayor's office. But the first thing that has to happen is the letter has to go out. And so the letter would, under, I believe, what your suggestions or decision is that the letter goes out and says the POC disagrees with the findings of the chief and the IRO and approves as the form.
And that puts the ball back in their court. My main concern here is that when folks have appeals and non-concurrences, we should provide as much information as possible so as to avoid any perception of collusion between the IRO's office and this commission. And so when you come in here and say, okay, what's the penalty for beating up a prisoner or a citizen, and what's the penalty for not having your camera on? Okay, let me guess this one. But then, when we have a witness, then we can feel a lot more comfortable in deciding in favor. You see what I'm saying? If we just sit here and the IRO comes in and says we have preponderant evidence here that says that this is what it is, I would like to have that evidence shared with us when there's complaints, and especially non-concurrences.
The rules and the ordinance, the current ordinance provides, and the union contract, which are the three things that govern how we operate, state that the POC does not receive the investigative file other than through oral testimony unless there is an appeal. And so we need to put the letter out there in all cases to give that decision to the appellant, the person who's complaining, whether or not they're going to appeal. And if they do appeal, then you get the investigative file. Without an appeal, you get live testimony from myself and the representative from the department. Other systems may be better or different, but that's the system we have right now.
Okay, well, Mr. Boyd, I think we have an issue here in that we voted. We had a motion and a second and we voted, but now we are faced with back to where we were some months ago, in that we have to approve the letter, inform but disagree with its findings, but we already have voted, so how do we handle that? Somebody let the man the microphone.
I would suggest a new motion indicating that the letter be approved as to form only, and then see how that vote goes.
Okay. Well, I will do that. I move to approve.
To clarify as to form only, based on Commissioner Foster, that means that the form of the letter is correct, that the IRO's statements of her position and the Chief of Police's position is correctly stated.
Right. Okay. So that again, I make a motion to approve CPC 112-12 with language added stating that this letter is approved in form, but the Police Oversight Commission disagrees with the findings. There's a second.
Second.
Okay, now, any discussion on that? All right. Hearing none, all those in favor of approving CPC 112-12 in form with the added language, we say aye. Aye. Okay.
The next non-concurrence case is 41-13.